Welcome to Conozca sus derechos, Know Your Rights. This program is brought to you by the Hispanic Bar Association of Central Florida. I am Camila Pachon Silva, the Community Relations Chair for the organization, and it is my pleasure to be here with you today. The mission of this show is to inform our community of important legal topics affecting us today. We'll be talking about consumer rights and in particular debt collection and bankruptcy. Our intention is not to discuss political opinions, but rather to simply inform the community of relevant topics that affect us all today. I am very thankful to have great speakers with us here today, Attorney Magda Lanza and Attorney Josue Merino. Magda, why don't you tell us a little bit about yourself?
Yeah, so I'm working for Community Legal Services of Mid-Florida, and I'm the supervisor of the consumer unit and the home preservation unit. In our office is based in Daytona Beach. We serve several counties. Among those are Orange County, Lake, Putnam County, Flagler. We have also Putnam, Flagler, Hernando Citrus, Marion, and Volusia County.
Josue, why don't you tell us a little bit about you?
Yes, I work with the Sanchez Law Group. I'm a partner there. Our firm, we have offices in Orlando and Kissimmee. We do a lot of real estate law, a lot of bankruptcy, a lot of consumer protection issues as well. We've been operational for over a decade.
Okay.
And we're here to serve Mid-Florida. So we operate in all the counties, I think aforementioned, but especially in the Orange County, Seminole, Osceola County region.
Okay, well, thank you both for being here. So let's just jump in. We know that due to difficult economic times, a lot of consumers here in Central Florida are finding themselves in debt. And then we want to make this show about what rights they have if they find themselves in these circumstances. Very few consumers know about the Florida Consumer Collection Practices Act. Can you tell us a little bit about the act? What does it do?
Yes, this act was enacted in 1993, and the purpose of the act is to protect consumers from abusive, deceptive, and misleading practices and tactics of debt collectors. So mainly, it gives us rights to the consumers and debtors, and they have the right just to prevent harassment from debt collectors.
Okay, so is this a state law or a federal law?
Well, we have two. We have the state law, which is the Florida Consumer Collection Act, and then we have the Federal Debt Collection Practices Act. So we want to keep in mind that we do have, in the federal level and state level, we have protection from both, level. But Florida supplements the federal federal statute, so which means it gives more. And the difference between the two those, even though they mirror each one, there is a difference because the federal one controls and supervise the collection, not supervise, but at least control and regulates the collection of debtors collection agency and debtors.
Okay.
And then the Florida statute includes also creditors.
Oh,
that's a
as
difference.
well.
That's a difference. So the federal one regulates the collection of collection agency and collectors, and the Florida one then also includes the creditors.
Okay, perfect. So what types of collection practices are prohibited under the state act?
Well, and Magda, exactly right. The intention, the purpose is to protect people from unduly harassment from their creditors. So, for example, a creditor cannot tell a third party about your debt. Now, it's limited to what they can do. They can collect your location, for example, but they can't inform that third party, your neighbor, your friends, your coworkers, your employer specifically, as to the fact that there's the existence of this debt. So if they find, if as a consumer you've become aware that that someone is calling your job, that is something they certainly can't do.
Okay.
Another example is the amount of times that they can try to collect the debt. They cannot call you every day in the morning and then at the evening, when in reality your circumstances haven't changed. One of the main questions a collection agent or a collector may ask you is your ability to make that payment. So if you've already informed them that you're unable to make the payment at this time, they have no legal purpose for trying to call you besides simply harassing you or trying to intimidate you into making that payment, and that is completely prohibited.
Okay, so you mentioned the call times. So are there restrictions as to the times that collectors are allowed to call you?
Certainly. They're not supposed to call after 9 o'clock in the night or not before 8 o'clock in the morning. And I would also would like to add as well that this collector cannot be threatening people.
Okay.
Or using any profane language or vulgar language, and they should not be telling the debtors that they're going to be facing jail or they're going to be arrested because they failed to pay any debt.
Okay.
So what that means is if they're going to be having any type of communication with the debtor, they have to abide by the regulation, federal regulation and Florida regulation, and they cannot be use any kind of misleading communication with the debtor.
Okay, so you said that they're not allowed to threaten you. Are we talking about threats of violence? Can they threaten you to sue you?
Well, in fact, the threatening nature is telling you that you're going to go to jail, for example, if you do not pay a debt. That is completely untrue. Or threatening you to take legal action when they really have no intention of actually doing so. Or garnishing your wages when they haven't even obtained a judgment against you for the amount of the debt that they're seeking to collect. So these are a few examples of where it's threatening, and it may intimidate the unknowing consumer into thinking, oh, I have to pay, or they're going to go into a bank account. They can't do that yet. They haven't gotten that far, perhaps, in the process. So that would be an example of some of the threats.
Okay, and in terms of being misleading, what type of tactics have you seen or have you heard that the debt collectors use in violation of the law to try to confuse people and pressure them into paying these debts?
Sometimes they might use the tactic of saying that they are representing they're calling from an office of an attorney.
Okay.
Or they are representing a law enforcement office. And they try to mislead people just to make them pay the debt. Also, if they know that the debt is barred by the statute, which means that they're dealing with a debt, they might call the person and trying to intimidate the debtor into paying the debt because it would be to the best, his best interest just to pay the debt, just to avoid any kind of legal process or going into prison. So those are tactics that usually they will use against the debtors to try to force, to lead them to pay a debt that probably is not even legal.
Okay. Does a collection agency, do they have to take you to court in order to collect on that debt?
That is correct. I mean, in order to collect on a debt, you first have to make it into a judgment. So you have to prove that, in fact, that debt is owed. And after they have a judgment, at that point, they can employ collection means such as garnishment or other means in order to collect the debt. But that's a process. That's a civil process. You have due process, and you can contest whether or not that debt is in fact valid. She raised a common defense, which is the statute of limitations, which means that the debt, even though it was incurred at some point, the time in order for you to sue and try to collect on it has already passed, and that's something that's commanded, and the timelines are set by statute. So
is that one timeline, or is the same statute of limitations for all debts, or it depends on the type of debt that is owed?
Well, it will depend on the state. Let's put it away. Let's say in the state of Florida, the statute of limitation for collection of debt is 5 years. Okay. Now, but it might be different in another state. So depending where the debt was incurred, where the credit card, in this case, let's say in this case, a credit card was taken in another state, then we have to look at what is the statute of limitation in that state.
In that state. Okay, okay. So what happens if somebody is going through that process and they watch the show and they know that the debt collector is violating this act? What can they do at that point?
Well, at that point, I certainly suggest that they consult with an attorney and discuss their legal rights. One of the things that a consumer should know is that they can tell the debt collector to stop calling them. And once they've become aware, they should make them aware that they should not call them at their work. They should clarify to them that this is my job number, you are not to call here, I cannot receive calls at work. But most importantly, inform the collector to stop calling them. And if they've sought an attorney, the debt collection directly to them has to stop from that point, because now the communications have to go from the collector directly to the attorney.
Okay, but then we're talking about people who are having financial problems. Chances are they're not going to be able to afford an attorney. What would be your recommendation in that case?
Well, in community legal services, we provide free consultation to low-income people, so they can call, our hotline, and they can be qualified for our services, and they can receive the assistance and advice of an attorney. But in addition to that, they can also send a cease and desist letter, which is nothing else but telling the creditor to stop making any phone calls or any more contact with them, and just to cease any collection effort. And that way, the person can send that letter directly to the creditor, and the creditor will have to stop making any calls. In addition to that, they can also file a complaint with the Florida Financial Commission regulation in the state of Florida, and they can also investigate that.
We're going to take a quick break, and when we come back, we will continue discussing the important topic of debt collection and what happens when the consumer is not able to pay their debts. Welcome back to Conozca sus Derechos, Know Your Rights, a program brought to you by the Hispanic Bar Association of Central Florida. I am Camila Pachon Silva, Community Relations Chair of the Hispanic Bar Association. Today, we're discussing the important topic of consumer rights and the area of debt collection and bankruptcy. So in the previous segment, we discussed the rights that consumers have when they find themselves in debt. So what happens if the consumer just finds that he or she is just not able to pay their debts back? What options do they have?
Well, in general, a few options will come to mind. One of them is simply settling the debts. At some point, a lot of these debts get to the point where a collection person is willing to accept less than what was originally owed. So you can consider, if that's an option, to try to get into a payment plan for a lesser amount.
And is that done outside of court, just a negotiation with the creditor?
Yes, and if it has turned into a lawsuit, it can happen also in court, but for the most part, yes, if they're trying to collect, a lot of the times they would be willing to accept less. The other alternative is filing a form of bankruptcy. There's a couple types of bankruptcy available to the consumer, Chapter 7 and Chapter 13 being the most common. And the first thing I would like to say on that note is that bankruptcy is actually titled a motion for relief. So individuals in that scenario where they find themselves that they cannot get out of this overwhelming debt, or they have a lot of credit cards with unbearable interest rates and they just pay the minimums and it goes on forever, should certainly consider that option.
Okay, but is filing for bankruptcy ever a good idea? Because now what we're seeing on TV and on these commercials, on billboards, is just like a restart button. They make it seem that it's something very straightforward, it's something very simple. Is it ever a good idea to file for bankruptcy?
Oh, that will depend, because if the person is looking for a job, or the person wants to relocate, and I always caution debtors, about that. If they're trying to relocate and move from one place to another place, or they're looking for a job, that may hurt their possibility of getting a job or getting another place once they file for bankruptcy.
And why is that? Why is it going to hurt them to find a job?
Because once the person files for bankruptcy, that's going to be reported in the credit bureau, and that's going to remain there for at least 8 to 10 years. And usually that's going to be background that's going to be done on the person whenever the person is looking for a job, employment, or the person is looking to relocate. So because of that, it will appear on the records, and it may affect the possibility of the person getting a job or being able to move to another place.
Okay. So it's a decision that they have to think about it very seriously.
Definitely.
Okay, so Josue, you mentioned the different types of bankruptcies. Can you expand on that a little bit more?
Sure. You have Chapter 7.
Okay.
Chapter 7 is the most common form of bankruptcy. It's called a liquidation bankruptcy or a straight bankruptcy. Essentially, what you're doing is accumulating all your debts, putting in what's called a bankruptcy petition, and filing that with the federal court in order to ask that they be discharged. Now, not all debts can be discharged, but commonly unsecured debts can be discharged. Just to give you an example of what an unsecured debt is, you have credit cards, medical bills, personal loans not guaranteed by some form of collateral. Those can all be discharged. Now, the most common ones that aren't dischargeable are IRS taxes, student loan debt, certain types of debt that they consider fraudulently obtained, but those would be, and child support and alimony. Those are ones that you just are never going to get discharged in a Chapter 7.
Okay, that is Chapter 7. So
Correct.
how about Chapter 13?
Well, Chapter 13 is a reorganization bankruptcy. To make it simple, Chapter 13 is just a repayment plan bankruptcy. There's a lot of certain situations where you don't qualify for Chapter 7, which is based on your income. And if you do not qualify, then you only have option of filing Chapter 13, which is where you're put into a payment plan with the bankruptcy court for a period of either 3 or 5 years.
Okay.
In a lot of scenarios, the Chapter 13 could be a great resource to help you save your home. For example, if you lost your employment or you've had a hardship and you got behind, let's say, 12 months, and you owe maybe $12,000, $15,000 just for the sake of an example. Well, if you file for Chapter 13 bankruptcy, the bankruptcy court forces your bank to take that $15,000 and allow you to repay that back over a period of either 3 or 5 years. So you can essentially pay back all of your debt over a certain period of time.
Okay. So do you think that Chapter 13 should always be Plan B? Or is there some circumstances where Chapter 13 may be the better option for the person?
Again, it will depend. If the person is looking to retain property, definitely Chapter 13 is the right one, just to propose a payment plan to the court and creditors to pay out the creditors through the plan between, again, 3 and 5 years as pointed by Jose.
Okay. What are the prerequisites to filing for bankruptcy? Is there something that the debtor needs to do before being able to go to court and ask for these debts to be discharged?
The debtor has to take what is called the credit counseling.
Okay.
That's one of the requirements that a person has to do in order for the person to file for bankruptcy. And also make sure that provides all the information and gather all the documents necessary to present to the trustee. Because once the person files for bankruptcy, there's going to be a person called trustee that's going to be assigned to the bankruptcy case, who's going to oversee the state of the debtor. And the trustee is going to be gathering some documents, requesting documents from the debtors pertaining to the finances. And those records needs to be provided to the trustee, because what's going to happen is that the case can get dismissed if the person fails to provide those records to the trustee. So it is crucial for the person to gather all those records, beforehand.
Okay.
Yes.
So what is credit counseling, Josue? What does that entail?
Well, and credit counseling, it's a course that's required by before you file for bankruptcy, and it kind of helps guide you as to how to manage your debt and your financial affairs, so that you don't find yourself in a situation perhaps in the future to have to file for bankruptcy. And I wanted to supplement something she mentioned earlier. The first thing when considering bankruptcy is, how do you qualify? Who can file bankruptcy? They look at the last 6 months of your income.
Okay.
And they compare that income to the Florida median income for how many live in your household size. And that's how they determine who can or cannot file for Chapter 7 or Chapter 13 alike. They're always going to look at the last 6 months of income. And
I would like to add, too, that the person must show that he or she has been residing in the particular state for at least 6 months, which is what we call domicile requirement.
Okay, and talking about going back to the credit counseling, can the person go to any credit counseling agency, or is there a list that the court has approved?
The agency has to be certified by the federal court, by the bankruptcy court, in order for the person to go to that particular credit counseling.
Okay.
Yes.
Is that an in-person class, or is that something that they can do online, and is there a fee for that?
You can take it online. There are telephonic, and you can take some in person, but there is a fee. The fees range. I think the least expensive one I found is $15 for the pre-filing bankruptcy fee. So you can get online, take a course for $15, and it helps you manage your debt. Okay.
How about the actual process of filing the bankruptcy? How much are the filing fees approximately?
It's 306, Jose?
It recently, I believe, went up to about 335, I believe. And then that's for Chapter 7. And then Chapter 13, I think, remained the same at about 285.
However, the person in Chapter 7, if the person is a low-income person, the person can request the court for a waiver.
Okay.
So that's important to keep in mind in case that the person is facing, usually they face some kind of financial difficulties and hardship, so they can request a waiver.
Okay. So is a person required to have an attorney to go through this process?
No, they are not. And actually here in Orange County, you can go and there's what's called a pro se clinic, that if you don't feel that you can afford an attorney, you can actually go to the federal courthouse and they have a pro se clinic which can help guide you as best they can in order to help you prepare the paperwork and at least get through the steps of the bankruptcy. So it's not a requirement.
But would you advise somebody to get an attorney to go through that process?
We do, in our office, we do have the pro bono attorneys, and they usually have clinics and they provide advice, and then after that the person is referred to go to a workshop in which they can learn how to complete the forms and the requirements, and they can do the process pleadings and then file it with the court.
Okay.
And I would certainly advise to use an attorney. One of the things is if you do not properly file your bankruptcy and for whatever reason it does get dismissed, you are barred, meaning you cannot refile immediately for a period of 6 months. So if you do not get it right the first time, it's not something that you can automatically just do it again until you get it right.
Okay. We talked about how long does the bankruptcy stay in your record, but how often is somebody able to file for bankruptcy? Is there a number of times that during a lifetime a person is allowed to file for a limitation as to the number of times somebody can do or go through that process?
No, there's not a cap. It's 8 years. So once you file, you cannot file successive Chapter 7s. You can't file again for a period of 8 years. Chapter 13, however, once you file, you can wait 4 years after you receive what's called your bankruptcy discharge. So it depends on which chapter, how many times you can file.
Okay. Attorney Lanza, Attorney Marino, thank you so much for being with us today and sharing very important information with our community.
You're welcome.
The Conozca Sus Derechos show of the Hispanic Bar Association of Central Florida is dedicated to service and education of our community. In our upcoming episodes, we will continue to discuss important issues for you and your family. We wish to thank Orange TV for their assistance in bringing you this program. For further information, please visit hbacf.com. Thank you for tuning in.